criminal charge committed against His Majesty's Revenue and Customs?
Now, Mr. Kadara, before we begin, I just ask you, is this one of the cases where the parties are having a transcript of the hearing prepared?
My lord, I had assumed so, but I haven't discussed it with anybody.
It's helpful for us to know because we don't need to take quite as many notes if there isn't.
May I turn around briefly? So they're here in spirit. They're here in spirit, and you will get a copy.
That's very helpful.
Great.
Yes, Mr. Kadara.
May it please the court, I appear for the appellant taxpayer, and my learned friends, Miss McCarthy and Mr. Ripley, appear for the Crown. And this is one of those cases where clarity is for both my clients and indeed the payments industry, or the payment services industry as I will describe them, is the paramount concern. Obviously everyone likes to win, but more importantly, it's a highly competitive market. It's a very important market. The court doesn't need to be told that. And at the moment, we assert, it is hard to know what turns a mere message, which is taxable, into a message which is exempt, if such a thing exists any longer. And it is given that messaging is at the core, and has been increasingly, obviously, over the centuries, of the movement of money ever since the Lombards developed bills of exchange, no more than a message. We're now in the current world where cash is in retreat, and messaging is happening all the time. So, and I know that no one underestimates the importance of the question. A tour d'horizon, very briefly, if I may, to indicate my proposed plan of attack. There are, first of all, there is the most important topic, which is the DPAS, the interaction between DPAS and SDC. And it is fairly binary, the way it's come before the court. We, until advised differently, believe that if we win the argument, it is not suggested. In other words, and by winning the argument, I define that as persuading the court that SDC is still the relevant yardstick for exemption or not, what my clients do, the kind of thing they do. If we win that argument, as I understand it, subject to correction later, then we will be in a position where we can re-establish the exemption. If we lose that argument, subject to the second point, which is slightly off to the side but not unimportant, that is to say, what I'll describe as the ATP point, that is whether just by holding the bank's ledgers and being the only repository of the record, there is some degree of exemption to be found. And equally, if we lose that point, let's say the first point, then it will be obviously impossible for exemption to be applied to the kind of service that my clients supply. So that's the ATP point. And the issue there for this court is looking at the language used by the Court of Appeal. Has there been, to use the specific words, an evolution or an elaboration of SDC in later case law? We say no. SDC remains unscathed and fully applicable. And that really is the first issue. It's quite binary. There doesn't seem at the moment to be any grey area between the parties. The second issue, which I've already adverted to, is the ATP point, and that's covered by the Court of Appeal at 103 to 109 of its decision, and that's the books of account point, which I have already mentioned. And there's a finding by the tribunal at 42, page 249, that those are the only record of transactions in respect of these mortgages. So that'll be the second point. There is then a cluster of 2 or 3 other points, potential points. Point 3, in the light of the outcome on points 1 and or 2, the so-called card protection point, assuming there is some potential for exemption, what my clients do, have they nonetheless lost the opportunity, because what they're really supplying to Shawbrook, the bank, their client bank, is something which is predominantly taxable, even though it might have potential to be exempt. There is no CPP point, of course, unless points 1 and or 2 have been to some extent won by the taxpayer. Then, point 4, the debt collection point, a point which I would venture to say is even more nuclear in its potential than point 1. Point 1 would only affect the payments industry, payment services suppliers such as my clients. Point 4, the debt collection point, would affect everyone who seeks to use the exemption in 13BD3, and that is an exemption which includes the operation of bank accounts. We'll open the exemption in a moment. So the debt collection point potentially could render 50% of every payment transaction taxable, because one is collecting, and the pushing side remaining presumably exempt, although there might be a scenario in which it's said directionality doesn't matter. So that's a very profound issue. And then finally, an issue which may or may not really come up, I call it the management of credit issue. It's dealt with, I should have said, the debt collection point is dealt with by the tribunal at paras 94 to 108. And as you know, the tribunal has decided that point against us. It hasn't arisen in the intervening layers. So it's really the view this court takes of the reasoning of the tribunal at 94 to 108. And then fifthly and finally, the management of credit point, if such it be, that also is something that has only really been dealt with by the tribunal. That's Tribunal 114 to 116, and we respectfully adopt the analysis that is to be seen there. So that concludes the overarching comment. May I now turn to issue 1, the DPAS issue, and may I invite the court to look, if it's handy, at 13BD3. It's at 577 of the electronic bundle, and it is there that one sees part of the 6th directive. This has now been replaced, but in virtually similar terms, under the principal VAT directive, so this case remains of great general importance. That's 577, 13BD3 of the 6th directive, and this comes under other exemptions. And if I can make a couple of comments about the context, because this is our battleground, obviously. The court is being asked to construe this provision, particularly 13BD3. But it's perhaps helpful just to get the broader picture for one moment. 13BD1, which may come up on the management of credit point at the end, exempts the grant and negotiation of credit and its management. We understand the word management there to refer to such things as credit checks, interest rate setting, policy decisions about who to lend to, and so forth. The actual transaction of credit being covered in the first 6 words, well, in fact, in the first by the word granting. As you can see, almost all of these, not quite all, but 13BD1 to 5 include negotiation. So to that extent, the exemption is broadened to include creating the relationships which then lead to the actual exempt transactions, but indeed the negotiation is a transaction, certainly for BD3 purposes. That's a point that simply sits in the background, but has maybe some importance. 13BD2 structure.
You say that the word negotiation there is being used in its bargaining or mediating sense, rather than the sense of what one does with a negotiable instrument.
Yes, I do say that. Not with any great confidence, because it's never been decided. I say it, and therefore I wouldn't exclude that for a moment, my lady. I say it simply because it appears everywhere through 13BD, but having said that, the word management appears in 4 places, and there is CJEU authority that the word management in BD5 has a completely different meaning from the word management in BD6. So I simply respond, it is possible. It would be a very specific use, but a transaction concerning a debt, for example, would include, or indeed a transaction concerning a check, or a transaction concerning a negotiable instrument. Those would all of them would include negotiating the negotiable instrument or checks. But I don't say it with particular confidence. I certainly, with great respect, don't rule it out as a possibility, but it may be redundant given the words around it. So 13BD2 has a similar structure to 13BD1. Sometimes the provisions describe the actual commercial transaction, the granting of credit. At other times, the word dealings is used, and in the one which we're focused on, in 13BD3, the portmanteau word starts it off, transactions, which is then given an inclusive and non-exhaustive definition. And once again, we have negotiation. And then a series of commercial descriptors, deposit and current accounts, payments, transfers, debts, checks, and other negotiable instruments. Just pausing there. So transactions concerning any of those are exempt. We know that a strict interpretation, an approach of strict interpretation, is appropriate for exemptions. But I would assert that the words deposit and current accounts, payments, transfers, debts, checks, and other negotiable instruments really just have one meaning. There's no reason, and no one proposes it either, to give them a restricted meaning. That would lead to a distortive approach to the market, with one type of check attracting exemption and another not. The focus of the entire case is on the word concerning, because concerning is pointing to the degree of relationship which the transaction, which is another word for supply, needs to have with the various commercial and financial nouns that follow it, and therefore it is there that already, we'll look at paragraph 66 of the Sparkus owners case, no doubt. The court has, the European Court has focused on what concerning includes and what it excludes. And we know from that, and we'll look at it, but I can briefly trail it, We know that having some kind of relationship is not enough. We know that being essential for the transaction to go through is not enough. We know from paragraph 66 of Sparkasonus that the concept involves altering the legal and financial landscape in respect of whatever the category of transaction is. The question is that any longer enough? And the main issue, the main DPAS issue is, if I can put it very starkly, does the transaction have to be affected by a bank? Is it the case now, post-DPAS, that you have to be a bank to perform a transaction? As I say, that word is simply another word for supply, concerning payments, transfers, debts. Do you have to be a bank? And the Crown says that the European Court has moved to that position. One immediate answer from us would be banks don't need that protection, because embedded within 13BD3 are transactions concerning deposit and current accounts. And those words give the banking sector all the cover it needs in order to maintain what has been the position, obviously, for many decades, which is that what banks do, the transactions that they perform, are exempt, not because of their status as a bank, but because what they do falls in one of 13BD1 to 6, but specifically in 13BD3, the operation of accounts. So if I ask my bank to activate a standing order, or if I simply use my telephone, as one does now, and ask my bank to pay a bill, it is operating a current or deposit account of mine, and therefore is completely assured of exempt status for what it does. And indeed, the Crown does not even remotely suggest that the contrary.
But if they didn't have exempt status, what is it that would be subject to VAT, or to what would VAT be applied? It can't be the amount you paid to the electricity company or whatever. It is the charge that they make to the customer for performing that service, or what?
My lady, it's a very, if I may say so, a very appropriate question. The amount that one pays to the electricity company, sadly, already has VAT on it. So no more will be added. So the actual sum of money is something out there in the world, as it were, which will be a debt which will or won't bear that. But my lady's question takes one to the question of bank charges. And insofar which are not ubiquitous, as far as I know, now in retail banking, and it may well, and indeed there is authority, we don't have it, we can find it, which says that banks do what they do for consideration, but the consideration, if there are no bank charges, the consideration is the agreement by the customers of the bank to abide by whatever the contracts are that they're bound by. So it's slightly amorphous. It's a decision, as I recall it, of Sir Stephen Oliver, but it's unlikely that will cause any problem in real life. But insofar as banks do make charges, and maybe in other countries at other times they have done, I'm familiar with Australia, where there has been a big culture of bank charges, slightly in retreat now, those bank charges would be exempt. But it would only be if the bank makes a tangible charge that it would need that. The downside from the bank's point of view, of course, is that while that means that the bank may not have to pay any VAT to the commissioners, the commissioners can block the bank's input tax recovery in respect of input tax incurred in the operation of current and deposit accounts, because the commissioners can say, and do say, you are an exempt entity, whether you charge your customers or not. What you're doing is making exempt supplies of the operation of bank accounts. Therefore, the VAT on your new mainframe computer, your electricity bill, and all of that, and people like my clients, of course, when my clients in this case are not working for a clearing bank, and we've abandoned the argument that there are current or deposit accounts in this story. But FDR and SDC, for example, worked for clearing banks, and the reason for the debate in those cases and in this is that the operations performed by banks, at least when there are current and deposit accounts involved, are exempt. And I'm careful not to use the word banking because it's too imprecise, because it leads to one slipping into the thought pattern that a bank is exempt. It's not. It's the operations that either do or don't bring the exemption. So just returning for a moment longer to 13BD3, so I've made the point that it's the word concerning that is the true epicenter of the debate. And we've got the final words, but excluding debt collection and factoring, which I won't say anything about now because I'm trying to stay focused on the DPAS issue, but that is a freestanding return to taxable status. I'll just say this much, if I may, that our submission on that will essentially be, it's a belt and braces exclusion, thus solicitors, bailiffs, enforcers, others who collect debts but do not form part of the sphere of financial transactions, they cannot try and get on board the exempt provisions in 13BD3, but I will come to that in due course. 13BD4 just deals with physical money, specie and its equivalent, and then 13BD5 and 6 deal with forms of collective investment. And as I say, the European Court has held that the word management in each of those bears a different meaning. One is transactional and the other is administrative. So the focus, as I've indicated, is on 13BD3. The phrase that I just used, the sphere of financial transactions, is the next point I would like to make. It is, in some ways, the centerpiece of the solution that we propose. It is a phrase which has become frequent in the European Court, particularly since the British tax avoidance schemes, which have been coming before it, that is to say, Bookit, DPAS, and AXA, although it was already in use in a case called Velvet and Steel. And let me, before I show you or give you the references to the relevant passages, let me explain. It's undoubtedly the case that in DPAS, the court did something and said something that it hasn't clearly said before to the taxpayer there, who was trying to exploit the fact that, in among the various things that it did, and I'll explain what it did later, there were some money movements. There was a direct debit instruction, and a taxpayer who did many different things, but had come before the court in that case, is not limited to that case, waiving the direct debit instruction, saying, look at us, we have at least a slice of exempt transactions. And the court, for reasons we'll look at, said no, But we say that the underlying policy of the court and of the exemption, particularly for 13BD3, is that it is limited to this idea, the sphere of financial transactions. Let me quote the words in a second, but the essential point is, in those cases where there's no avoidance, what comes before the court is an SDC character or an FDR EDS character, or Nordea, a messaging, Swift messaging service, or a card point character. In that case, they dealt with the hole-in-the-wall machines. Those are all what I would describe as normal 13BD3 cases. Normal in the sense that in each of those 5 cases, 3 European, 2 UK, the client was a bank, and the bank was subcontracting to this third party various processes which it needed to deliver, in some cases, the operation of a current account, in other cases, the grant of credit. In the case before this court, it's overheads in connection with the grant of credit. In SDC, it could be any of them. In FDR, it was overheads in connection with credit cards and debit cards. Every case is different, but what unifies those 5 cases is they're all cases where a bank is the customer, and there is no doubt that the bank operates wholly and solely in the sphere of financial transactions. It didn't need to be said. And what I say the court is indicating in its use of this phrase is that if, on the other hand, entities that do not operate in the sphere of financial transactions want to use 13BD3, then it's highly unlikely that they will be allowed to, particularly if they are making principal supplies of things completely unrelated to the banking processes, selling theatre tickets, organising or delivering dental care, and mobile phone services, in the case of E&E. And that barrier that the court has erected is only for them, and it goes slightly further because, as we'll see in those cases, they are consuming banking services, as we'll see from NEC and Bookit, for example, but also DPAS. The entity is actually a creditor in its own right. So it is seeking both to consume financial services while asserting that it is making a supply of financial services.
Which is the entity in that?
Forgive me, the unsuccessful taxpayers in the British avoidance cases. And they're also making supplies which are outside the sphere of financial transactions. And insofar as in DPAS, the European Court raised the bar for entry to 13BD3, it was doing this in the context of what we would say is, if not abuse, certainly activities that fall outside the scope of BD3. And may I add one more thing before I try and make this good? The way that we say the court puts it is, we allow anyone into 13BD3. We don't require that they're a bank. but they have to be wholly engaged in the sphere of financial transactions if they want entry. So in the last 3 or 4 minutes, I've outlined the core theory of why we say 13BD3 still works for the likes of SDC, EDS, FDR, but has never been available for the likes of Bookit, NEC, DPAS, and so forth. I've got, the quote appears 4 times. I will only read it once, but I will give you, it's always slightly different. I will give you the references if I may. The first place is in...
This is the phrase that you've just been...
This is the phrase, yes. First place is in Bookit. That's at tab 12 in page 727 is not the first page of the case, but it's the place where paragraphs 35 to 38 appear. So, page 727, paragraphs 35 to 38. So this is the court explaining why Bookit are not going to be permitted to enter the exemption. We'll come back to the case properly, if I may, a bit later. 35, the court begins, it mentions the replacement provision of 13BD3. So that's 1351D. It says at 36, the transactions exempted under that provision are defined in terms of the nature of the services provided and not in terms of the person supplying or receiving the service. And they go on to make the point that therefore you do not have to be a bank, I can summarize. And 37 I skip. And then 38, court says this, in that regard, the court has previously held that a transfer is a transaction consisting in the execution of an order for the transfer of a sum of money from one bank account to another. It's characterized in particular by the fact that it involves a change in the legal and financial situation existing on the one hand between the person giving the order and the recipient, and on the other between those parties and their respective banks, and in some cases between those banks. Moreover, the transaction which produces the change is solely the transfer of funds between accounts, irrespective of its cause. Thus, a transfer being only a means of transmitting funds, the functional aspects of it are decisive, forgive me, for the purpose of determining whether a transaction constitutes a transfer. So, from 35 to 38, one has the indication at 36 that the exemption isn't subject to, as it were, an entry requirement of status. Where the transactions in question relate to the sphere of financial transactions. And it is that phrase which appears, if I can just pinpoint it in its other manifestations, at DPAS at divider 14 at page 767. At 31, if I may, so that's page 767, DPAS 31, speaking again of what was once 13BD3, if I can just take it up at the third line of 31, quote, accordingly, the exemption is subject not to the condition that the transactions be affected by a certain type of institution or legal person, but to the condition that the transactions in question relate to the sphere of financial transactions. And then it goes on in the same way. And if I can just indicate that similar wording appears at Velvet and Steel, tab 31 of the supplementary bundle, not identical wording, at paragraphs 20 to 23 on page 1142 of the bundle.
I'm sorry, which bundle is this?
My lord, it's the physical bundle is the second bundle of cases, but following it on screen, it should be page 1142.
Oh, yes, I've got it.
Page 1142.
Yep, thank you.
And what was the page for the DPAS quote?
And the page for the DPAS quote,
767.
I'm grateful. So at 1142, of Velvet and Steel, it's 20 to 23. If you'd be kind enough to look at para 22, the third sentence of para 22 reads, although those transactions defined according to the nature of the services provided do not necessarily have to be carried out by banks or other financial institutions, they relate nevertheless as a whole to the sphere of financial transactions. And then, perhaps without troubling you with reading the words, may I simply add the reference to the fourth case, which is AXA tab 8. AXA tab 8, electronic bundle page 659, paragraphs 25 to 26. So the point I seek to get from that is that what the court is saying is, coming back to 13BD3, this is a very specific exemption which just focuses, without asking who is doing it, what's their status, on the transaction. But the bargain is that you have to be someone who's engaged, perhaps wholly engaged, in the sphere of financial transactions. And sphere is an unusual word in the world of VAT, in the sense that VAT is very, very siloed. It looks at supplies, it looks at inputs, outputs, very specifically. The court, from Velvet onwards, has thought it necessary to reinforce that we are dealing with an exemption which operates in a particular sphere. And in my submission, if one accepts that, that is the thread that will enable the court to conclude that SDC remains good law. And I'll develop that as we look at the cases.
So it's because Shawbrook is dealing with mortgages and they are in the sphere of financial transactions that you say you're different from Bookit and NEC and DPAS.
Yes, my lady, and the same would be true of the Sparkasonas narrative.
It's true of
SDC. The same would be true of SDC, which we'll look at. In other words, when the customer is a bank, there is no card protection plan inquiry needed, because the banks are only interested in receiving financial services. And the data handling service, which was held in the SDC case to be exempt, as long as it was used actually to effect or to execute transactions falls entirely within the exemption. When it comes to the British cases, what one had was different industries, and as we'll see, issues of value shifting, moving turnover from taxable to exempt, and the court wished to and did defeat the planning in the way, obviously, that you've seen. But we say that is not needed in this case because we are already within the exemption. Because what we are doing is providing inputs into the supply chain known as the sphere of financial transactions. So there is no risk of the exemption being diverted as long as we can satisfy inter alia the requirements of STC para 66. Just before I open the cases, can I, as it were, flip to the other side of the argument? The effect, we say, of taking the DPAS approach and applying it across the board to the industry is that you have to be a bank.
Is that you have to?
You have to be a bank. Because what's said in the Court of Appeal, I won't open it just yet, but merely sending messages will not suffice. And it follows from that, given that everything needs messages these days, only a bank can perform this approach, those transactions concerning payment and so forth. And that would be a striking outcome, given that in SDC, back in the 90s, the Advocate General said, in his opinion, you had to be a bank. And the court, European Court, thought about that for a year and then disagreed with him. And one of the mantras, and indeed the court has already seen that this morning in various quotes, about 13BD3 is, we don't ask who you are, we just look at what you do. You don't have to be a bank, but, and it was that open door policy that was exploited in the British cases by people turning up and saying, don't worry about the ticket sales, don't worry about the fillings. Look, we're sending a direct debit instruction, or therefore we bring ourselves within the exemption. And the court has, if I may say so, elegantly constructed a barrier against that kind of use. The question, obviously, did it go a bit too far and exclude everybody else? So if I can, there's one other point to make. Even if one is a bank, this is the question of, can payments really ever happen without cooperation? We've all had the experience of sending the money. It's less frequent now, but sending the money on Monday and it's not arriving for some days, sending money through the banking system. And that underlines the point that you need both the entries in the account of the paying party to be altered, so that what was a credit is reduced, and also entries in the account of the receiving party's bank to be altered. And there's no dispute between us that Lord Justice Laws in FDRs, we'll see, was correct when he said that there is no shadow world. Money never really moves. It's simply entries in one bank going down and in another bank coming up. So In this super rigorous world, although it doesn't really matter because banks are exempt because of the operation of current accounts, it would be possible to say not even a bank can unilaterally make money move. It does depend on cooperation, and also the evidence is that even banks require the assistance of the Bank of England where they all have accounts, and ultimately a set-off happens. So it is intrinsically a multi-party process. So if I may move to the next short point, the court has the benefit, obviously, of the statement of facts, and it's more of a factual, very short factual point, just to give some references. Obviously, it's pure questions of law. The court has the benefit of the statement of facts and issues. The court will appreciate it's a rather unusual looking statement of facts and issues because we didn't have the advantage of fact-finding by the first tier against the background of the DPAS litigation. So we are where we are, and the processes whereby money moves are, with respect, sufficiently well known for judicial notice to be taken of them. But we don't have detail. For example, we don't have copies of the BACS rules and so forth. However, we do have the advantage that I believe it to be common ground that what BACS does is exempt. We'll see if that's confirmed. But that would be a very important point, because what BACS does is to take the messages that my clients and others generate and feed them into the system. My clients are sponsored by Shawbrook, and that means that they can access BACS as if they were a bank. So they have the umbrella sponsorship of Shawbrook, and they, therefore, are in exactly the same position that FDR was in its case, as we'll see. And one question, given that BACS is not a bank, is how could it be consistent with principle that it nonetheless is exempt, and we'll see where that...
So Shawbrook is a member of BACS, is it?
Yes.
And does BACS charge its members for the services it provides?
My lord, I don't know, but I presume so, and I can take instructions. There are rules, which is another way of saying that there is a contract.
Yeah.
One suspects the rules deal with all those issues, but I would be going beyond the evidence. I haven't seen these contracts, in fact.
But when you say it's common ground that BACS, if it does charge in some way, that would be exempt, is it common ground that it is exempt under 13B(d)(3) or under some other exemption?
I don't recall any other possibility, but I must confess I have assumed if it is common ground that it would have to be under 13B(d)(3). We can ponder whether there might be another route. But
Well, HMRC presumably no.
exactly, and in due course, my friend will no doubt take instructions. Just very briefly, so that the court knows, you have the statement of facts and issues, of course, you've got the summary by the Court of Appeal, but just going back to the origins, the fact-finding by the tribunal, the fact-finding paragraphs there, if at any stage the court needs to consult them, are to be found between paragraphs 29 and 57. The witness evidence was completely accepted. And the specific technical evidence is at paragraphs 42, 48 to 57. 42 on page 249, the tribunal holds that that Target keeps the bank's ledgers and that there is no other record. At 43, on page 250, the tribunal holds that Target operate the clearing bank accounts of Shawbrook in its clearing banks, that is to say NatWest and RBS. So it has full access to and control over those. There's a more general description at 46. Backs and chaps are described at 48, page 251. And then it returns to the subject at paragraph 87 of page 262. There is a contract which I don't propose that the court needs to read, but may I just say this? There is a point in the air sometimes as to what degree of responsibility the entity in the position of my clients assumes in connection with the process that it is curating. There is a limitation of liability clause in the contract. It's clause 13, page 305. But my clients, clause 13, page 305, my clients are responsible for the first £1 million of damage caused to Shawbrook if they make a mess of things. So there is, to that extent, exposure. A couple of other factual matters. My clients are given agency status under the contract on behalf of Shawbrook. That's clause 4.5 on E-bundle, page 286. And as is found by the tribunal, my clients are paid mainly on a per loan basis. There's some standard charges, but the consideration for what my clients do is calculated on the basis of the number of loans. So may I now pass to the first of the cases, and the case that I say is still good law, that is to say SDC. I propose to just remind the court what that says and then briefly compare it to both FDR and then to what the Court of Appeal has said in this case, so that you can see the gap between the two sides, as it were. The SDC case is in the electronic bundle. It's at tab 5 and the electronic bundle 593. So this was a case dating from the mid-90s, and SDC was essentially an analogue of FDR. As you can see, it was, just for the first few lines of the head note, it was an association in Denmark, most of whose members were savings banks, and it provided, partly by electronic means, to its members and other customers connected to its data handling network, services comprising the execution of transfers, provision of advice on trading securities, and the management of deposits, purchase contracts, and loans. So pausing there was an array of services. Ultimately, only the service comprising the execution of transfers was held to be exempt. And if one goes straight to page 609, I'm not dipping into the Advocate General yet, because he took a different view, as I've indicated. So at 609, paras 8, 9, and 11 give the court a flavour of what they did. I will pause, if I may, so that the court can have a look at those.
Yes.
And as one can see, it's therefore a data handling network, and it's no coincidence that SDC, FDR, and EDS all have D in their name. And it interacts, its client is the bank, but it interacts directly with customers who have been authorized, and it's invisible to those customers. And then at electronic 613, paras 40 to 41, we see that 13BD3 and 5 are in play. We're not concerned in 5. I ask the court just to glance at 40 and 41. Those were the competing contentions. And then at page 614, 46 to 47,
we could just pausing just there. It looks rather as though the argument was whether the bank had to perform the service itself, or whether the exemption could be claimed if it was performed by a subcontractor.
My lord, exactly right. And we say that's a point to which we have now been returned by the Court of Appeal judgment in this case. I was proposing the court look at 46 to 47.
So the United Kingdom government was arguing that it was covered by the exemption, paragraph 4.
In the specific circumstances of the case. So I'm proposing that the court look at 46, 47, and 50 is important. I will indicate as I go through which of these paragraphs are adopted and approved in DPAS, because one of the circumstantial pieces of evidence which the court may care to bear in mind is how far it's proposed that DPAS has in effect departed from this case, but we say no, and paragraph 50 is specifically approved in DPAS. It must be added that the considerations relating to transfers set out below are also applicable to transactions concerning payments, insofar as the factual circumstances and the contractual links are similar. Moreover, no distinction in this regard has been raised by the parties in the proceedings before the court, and that, for our part, remains the case today. Debts are slightly different. So that's 50, but if one goes to 58, well, page 615, I think generally is the most important page. So I'm wondering if I could just take it from the top. Para 53 at the top of electronic page 615 is also approved in DPAS. And it is critical in the sense that the Court of Appeal, in our case, focused on the word execution and held that only a bank ultimately can execute. And at 53, on the basis of DPAS, In 53, execution is not said to be specific to a bank or to any particular player in the story. And the phrase is execution of an order for the transfer of a sum of money. So carrying out an order is a compendious phrase, all of which is, we say, relevant for the application of the exemption. Not just the final moment, but the process. The change in the legal and financial situation we come back to under paragraph 66. And then importantly, halfway down 53, these words appear: moreover, the transaction which produces this change is solely the transfer of funds between accounts, irrespective of its cause. Thus, a transfer being only a means of transmitting funds, the functional aspects are decisive for the purpose of determining whether a transaction constitutes a transfer for the purposes of the Sixth Directive. So in our case, for example, when my client activates the direct debit which it has been furnished with by the borrower, and my client activates that as the agent of its own customer, Shawbrook, that causes monies to leave the clearing bank of the borrower. Well, they may not arrive, but there has certainly been a change in the financial situation. Certainly the debt situation between the borrower and its bank has altered. Obviously, it doesn't stop there, because then the money arrives in the Shawbrook account, having gone via the Bank of England, and the pro and the con entries having been made, and my clients are there when that money arrives, and they allot the money to the appropriate accounts as between, I'm not talking yet about ledgers, I'm talking about Shawbrook bank accounts. So we have control of all of that.
I've found myself reading these sentences more than once, and one's told by the first sentence that a transfer is a transaction consisting of the execution of an order for the transfer of a sum of money from one bank account to another. And then the third sentence, we're told the transaction which produces this change is the transfer of funds between accounts. So the transfer is the transaction is the transfer.
Circular.
One seems to be going round in circles.
It may be that they were attempting too high a level of generality in terms of what they were trying to achieve.
Well, they repeat this same phraseology over and over.
Yeah.
It doesn't actually mean anything when you... It doesn't convey any meaning.
Yes, but that's exactly it. I've read this again and again, and I don't feel,
It's not
as
clear
the
what
leadership says, no meaning is being... There's no transfer of meaning, if you like, from the text to my mind.
They're obviously trying to get at something. They're trying to describe something.
Yes.
But it's a bit mysterious what it is they're trying to describe.
It may well be that they're somewhat hampered by the extremely laconic wording in the exemption itself. They don't want to add anything to it to make it any wider than it is. And as we've seen, there's no gatekeeper saying, are you a bank? So anyone can turn up and say, oh, I've done a financial transaction. But that's a point I will come to. It may be that it gets a little bit clearer in practical terms if one reads the next paragraph. So if one could suspend one's disbelief for a moment. In cases where the customer effects a transfer or causes a transfer to be effected without any action by the bank, the specific acts which constitute the transfer are carried out either by the data handling centre and the customer, or by the data handling centre and a third party, the latter acting at the customer's request, or by the data handling centre acting alone pursuant to a standing order from the customer. So pausing there, at least we've got slightly more concrete at this stage. And what I invite the court to take from this, because ultimately the road is going back to the Court of Appeal saying only a bank can execute. What I invite the court to take from 54 is that execution is a broader church, as it were, than the Court of Appeal in our case have taken it to be. And the specific acts which constitute it can either be carried out by combination of data handler and customer. For example, I put my debit card into a hole-in-the-wall machine and the money comes out, or I use my debit card at the till and I buy my goods. Customer, a data handler and the third party. So I might send money through what appears to be my bank, but actually it's an FDR, SDC type entity. Or the last sentence, which we say is a point of collision with the Court of Appeal, or by the data handling centre acting alone pursuant to a standing order from the customer. So at the level of generality of an exemption, which is obviously designed to capture practices in multiple countries in Europe, the question of effecting a transfer, and I'm mindful of the fact that execution appears in the first sentence of the previous one, is given a broad and practical meaning. And implicit, I say, in 54, is that there is, of course, a contractual or legal right or entitlement that is being exercised. The customer has got a credit balance, for example, and it's in a contractual relationship with SDC's principal, one of the banks. So these are the silent premise of an effective message is that it fits in with a pre-existing relationship. And at 55, dealing with the point that the Advocate General fastened on, the court says the contractual link between the bank and its customer do not diminish the role of the data handling centre. That's a very important point, because what was proposed unsuccessfully is that the customer only has a contract with the bank, and it is therefore only conceivable that this exemption would apply to the actions of the bank. Whereas it's inherent in the case before this court, SDC FDR, that the exemption also applies to those to whom the bank subcontracts fulfillment of its banking contract. And of course, that's the data handling centre. So at 55, they explain how the customer has the right, but the focus of 55 is that inputs, overheads of the bank, which are wholly within the sphere of financial transactions, can independently enjoy the exemption. And the 56, it makes the point, moreover, if point 3 of Article 13BD of the 6th Directive covered only the service which a financial institution provides to the end customer, only certain acts concerning transfer transactions would be exempt. Such interpretation would restrict the exemption in a way which is not supported by the wording of the provision in question. That wording doesn't restrict the exemption to that relation, and it is sufficiently broad to include services provided by operators other than banks to persons other than their end customers. And that, we say, cannot stand with the approach of the Court of Appeal in this case, which is to say only a bank can execute, and therefore only a bank can have the benefit of the exemption. And the tax story behind all of this is that therefore the bank must incur VAT from its subcontractors, even if they do the very thing that the bank itself is going to do in an exempt way, because they can't enjoy the exemption. They have to charge the bank VAT. They can't share, if you like, in the bank's exemption.
That's what the Court of Appeal decided.
And that's exactly what the Court of Appeal decided, that they can't share in the bank's exemption.
So are you saying that what SDC is saying in effect is that given that if the bank itself was doing this, it would not be bound to charge its end customer VAT?
Yes.
If it imposed a bank charge for this, if they choose to subcontract that, then they're no worse off because the subcontractor doesn't have to charge them irrecoverable input VAT.
That's what this entire litigation is about.
Yes.
Do we know what exactly SDC, the entity, actually did?
We can know more if we go back to, my Lord, well, I was about to go back to the Advocate General. I wonder if I could just postpone that pleasure,
Yes.
because there is a heading, the bottom of this page, Data Handling Services and Their Character, which no, my Lord, may I just look back? It stays rather conceptual. Just let me look back and see if the Advocate General so if we look back to the Advocate General, this may be a partial answer. On electronic page 598 at 16, there is, I won't read it aloud, but if the court may care to cast an eye on paragraph 16, that may fill in some of, not that informative. It's a lower level of detail than we have, say, in FDR, and we do have Lord Justice Law saying FDR does what SDC did, so we can tap into a little bit of added detail. Of course, what one sees in 16 of the Advocate General is very broad, and it's critical that the banks suffer irrecoverable VAT for all their inputs that don't fall within 13BD3, electricity, telephones, couriers, and so forth. And that is the challenge which the court in SDC comes to next. But it makes the point at 56, which I've already indicated, the last sentence, that the wording is, quote, sufficiently broad to include services provided by operators other than banks to persons other than their end customers. And straight away one can see that there is a self-regulating mechanism built in. It's not just any inputs that the bank incurs. It will be inputs that involve a an interaction with a bank's customer. As my lady was putting it to me, it's really, if the bank is doing something exempt and it subcontracts that something, then that something can also benefit from the exemption.
And it may be the reason why the court and the Advocate General didn't actually explain what SDC did, was that because that wasn't the focus of the argument. The argument seems to have been simply that if a bank chooses to subcontract its operation, then it loses the exemption.
Or the subcontractor cannot access the exemption.
Yes, yes, what I mean, yes. Yeah.
My Lord, if I may say so, I think that's absolutely right. It was very much at a level of principle that they were dealing with it.
But isn't the counter-argument to that rather difficult to understand sentence in Velvet and Steel, to which one is always pointed as to why is there this exemption, is because it's very difficult to work out what to attach the VAT to. What should the VAT be a percentage of in order to collect it? And as we were discussing a little while ago, when a bank doesn't charge a customer for transactions but gets its consideration either from a promise or the ability to use that money and make more money from that money than it pays to the customer, then one can see it's very difficult to make that a vatable supply, just the practicalities of it. Whereas with a subcontractor, charges a fee, and it's very simple to add 20% onto that. Isn't that's the part of the reason why it said there's no need for this exemption to apply to the subcontracted services, whereas it does need to apply to where the bank effectively provides those services to its own customers?
My lady, that is certainly one of the points that the Crown is making. But Velvet, if I can digress and begin the answer to that, Velvet and Steel is a quite a delicate instrument to use because it has two parts. One, my lady has put to me, which is that's why we have exemption. But if one looks at 13BD at high level again, there is subcontracting ex facie, the 4 references to management, for example. Those will all, or can all, tend to involve subcontractors, trustees, unit trustees and custodians and so forth. Secondly, negotiation will often involve commissions and so forth. So it's not a ubiquitous problem. Another way of looking at exemption is that it's actually difficult to see what the value add is in financial services, which is almost the same point that my lady put to me, but slightly wider, and it is a value added tax. The second half, my last brief comment, of Velvet and Steel is as long as it doesn't put up the price of consumer credit. So it's quite a delicate piece of machinery, the financial services exemption. And while different countries define consumer credit in different ways, there is clearly a case for taking the view that mortgage, unfortunately rather topical subject, mortgage interest is part of the consumer credit world. So just 3 rather random responses. I apologize to the Velvet and Steel point, and we may come back to it. Coming back to SDC, having given a very broad gateway in 53 to 59, the court then focuses in 60 to 68 on what it is the subcontractor's service must achieve if it is to share the exemption of the bank. And what it is principally set out in paras 64 66, 67, 68, they're all on electronic page 616. And I pick those, 64, 66, 67, 68, because they are all approved in DPAS. '64 is, again, antithetical to the approach taken by the Court of Appeal. The Court of Appeal focuses on the final moment of execution, whereas we say, as a matter of fact, it's a cooperative process moving money from Bank A to Bank B. Secondly, in Para 64, the European Court seems to acknowledge that one may well have a series of transactions. One has in mind Lord Justice Staunton's summary in Libyan Bank and the court needs no reminding of how complex matters can be. But even in our simple story, there's a movement from the borrower's bank account, out of that, through the system, through the Bank of England and back down into the lender's bank account. And each of those stages involves a different debt. And if one is going to go down to that level, because one's got the overarching debt, of course, between Shawbrook and the borrower, and one's then got the mini debts between those entities and their respective clearing banks, and then the clearing banks between each other, and so on. My submission is this 64 is likely to have had that process in mind. It remains high level, as my Lord Lord Reed puts to me, but it has to be, I guess, because they don't know more than very, very briefly what the individual facts of an individual case would be. 66 is a critical case, as I say, approved in DPAS, and for a case such as the present, I'm not sure how far it is actually said that my client's actions don't result in any change in the legal and financial situation. If it is, that would be wrong, and I'm not sure if the Court of Appeal quite went that far, but what the Court of Appeal did say was that it is only a bank who can ultimately execute the transfer, and we say that 66 is broader than that. And this comes back to messaging. Why are messages sent? They're sent in order to instruct someone to do something. There's only one category of act that matters, that is the making of entries in banks' books. So the European Court must be taken to have known that. That must be universal in terms of banking, the modern banking world. It endorsed the use of a data handler to cause events of the sort it mentions in 53 and 66. That can only be in the context of the data handler sending messages which then trigger the making of the relevant entries by the banks. Only the banks ultimately can make those entries.
Couldn't the banks contract out their bookkeeping?
Yes, indeed. They could, and I think in FDR they did, in a very narrow area.
So I mean, in that situation, the person who actually held the books and made the entries wouldn't be the bank.
Indeed. My lord, yes.
Mm-hmm.
Just going back to the Advocate General's argument, Advocate General's opinion at 603. At paragraphs 52 onwards, they describe the argument, if we did this ourselves it would be exempt, and so if we subcontracted it should also be exempt for sort of fiscal neutrality
Indeed.
reasons. Now that seems at 55 to be rejected by the Advocate General.
Yes.
But did the court either differ from or approve that particular passage in the Advocate General's?
It certainly didn't approve of it. They don't mention his view. His proposed answers, if one looks, I mean, their answer and his answer were really diametrically different. His answers are at the bottom of page 607, and at sub 2, well, sub 1 and sub 2, he says in 1, he says the exemptions which he refers to do not make the transactions concerned necessarily dependent upon a part being played by a financial institution, bank or savings bank. But he goes on to say at 2, when a financial institution which provides its customers with financial services plays a part in transactions which are exempt by virtue of the said provisions, the scope of the exemption is restricted to the corresponding legal operations carried out by the said institution with its customers. And here are the key words, but does not extend to the performance of auxiliary or instrumental services with which an external undertaking, distinct from the credit institution, may supply in the form of electronic data handling or in general electronic transmission of information for the performance of the institution's own banking transactions. And we say that the Court of Appeal have brought us back to something very similar to that.
But that was not the conclusion that the court came to.
No, the conclusion of the court, if I can jump to that, conclusion number 1 on page 618 is similar to the Advocate General's. So the exemption isn't subject to the identity condition, or indeed is not interested in whether anything's done electronically or not. 2, the exemption provided for points 3 and 5 of the SIC directive is not subject to the condition that the service be provided by an institution which has a legal relationship with the end customer. The fact that a transaction covered by those provisions is effected by a third party but appears to the end customer to be a service provided by the bank doesn't preclude exemption for the transaction. So that opens the door to the subcontractor chain to share in the exemption. And the next point is also similarly important, that the provision is to be interpreted as meaning that transactions concerning transfers and payments include operations carried out by a data handling centre if those operations are distinct in character and are specific to and essential for the exempt transactions. And then 4, on the other side of the line, is information only. So the battleground before this court, I submit, is 3. Is that still the position? Can operations carried out by a data handling centre, if sufficiently distinct and specific, can they enjoy independently the exemption?
The implication of the passage that her ladyship drew attention to in the Advocate General 52 and 53 is that the is that SDC was actually executing transfer transactions.
Yes. And that's the battleground for this hearing.
So the only a bank might have its own data center where customers' accounts are held in a database on its own computers and has its own maintenance staff and so on and so forth. And all that's happened is they've contracted that out.
That's exactly right, with respect. And that's what's been happening the last 20 years. It's outsourcing. And so the two are aligned, as it were, left aligned by SDC. I think I probably troubled the court sufficiently with that case. And may I briefly show the court FDR, which we say, appears in the electronic bundle at 855. FDR survives or not, according to the view this court takes of SDC. Obviously, it's only a Court of Appeal decision. So my only purpose in showing you FDR is to really just give some factual, technical background, partly because it finds its way into the fact findings of the tribunal in our case by reference to the tribunal's adopting as part of its findings what Lord Justice Law said on backs. So if I can simply, without reading, point out the key passages. It's 864. I'm passing over the facts. I've asserted that it's very similar, but every case will be somewhat different, of course, in the detail. At 864, His Lordship deals at 23 to 25 with how BACS works. So, and that's ingested into the factual findings of our case. It's not in dispute. He then reviews SDC at paras 30 on page 866 through to 34 on page 869. On page 869, he says at the bottom of para 35, I said para 34, I should have said para 35. His very last sentence of para 35 is, I must test what FDR actually do against the reasoning in SDC, and do so in three ways. A, transfers and backs, B, transfers and netting off, and C, transfers and the cardholder merchant accounts. So we're not concerned with B in our particular story. A, of course, is central. There is then a, if I may say so, very helpful section on how money moves between para 36, page 869 of the bundle, to 871, para 38 on page 871. And he says at 38, reminding us that he says in the second sentence of 38, it demonstrates that what the 6th Directive imports by the term transfer inheres in the notion of a change in the legal and financial situation, an expression used in both paras 53 and 66, where that is a reference to the effects of the corresponding credit and debit entries in the accounts of the paying and receiving parties. This is a point which in my judgment possesses particular resonance when one comes to council submissions relating to netting off, with which we're not concerned. And then there is a section which is highly material in a factual sense, on page 871, 40 to 42, and he says at 42, speaking of Bax, that in his judgment, quote, it is in my judgment of the first importance to recognise that Bax, for its own part, exercises no judgment or discretion whatsoever. Once the relevant tape is prepared, and that is admittedly done by FDR, and delivered to Bax, the process is, as I have said, automatic.
Does that make any difference? Right.
I mean, in a sort of non-analytical way, but what matters is that there has been a triggering of the process, and whether Bax check or don't check, it's what happens that matters.
Yeah. But if he goes on to say that Bax is merely the agency by which FDR effects transfers, then is Bax not, on that analysis, the one that's entitled to the exemption?
Well, Bax is we support, as it were, the exemption for Bax, for obvious reasons of self-interest. But Bax is no more of a bank than we are. It's just another data handler. So that the divide really is between the banks and the data handlers. And if necessary, there's case law in the bundle which indicates that when you have an exemption and then there's a sub-agent to whom the exempt subcontractor subcontracts, then they are entitled to also to the benefit of the exemption, assuming that they're just doing the same thing. But this is of the essence. My Lord's question touches on the essence of the passing of the baton along the chain. And we say the baton is the same baton, and it should attract either the same tax or the same exemption, as long as people are just passing it along and doing the same thing.
Well, there's a... Sorry.
No, Karen.
In a way, one could say, well, Target doesn't really exercise any discretion. It knows which customers owe which amounts of money, because that's what Shawbrook tells it. I suppose it could go rogue one day and just mischievously start deducting all sorts of wrong amounts, which is something that Bax can't do, as I understand it. Bax can only, unless there's a glitch in the computer, but assuming the computer is working smoothly, it can only do what it's told, whereas Target should do what it's told, but could decide not to.
I take that and respectfully would say if it certainly wouldn't merit exemption any less. We are the originator of the message, so we have that special role. My lady says Target do what Shawbrook tell them to do. In fact, it's more nuanced. Shawbrook say, just get on with it, and we tell Shawbrook in practice what's due to them and when. So we are I suppose we form the baton that gets passed in a way, always against the background of a pre-existing loan. But it's Target that decides how much goes into the message, when the message gets sent, and so forth. But once that's been put together, then it's going to be the same message all along the line. I mean, it used to be done by men on motorcycles going up the M1 with the tapes. I think that's somewhere in FDR. Now it's just the press of a button. But
and I think the explanation that Lord Justice Laws gives on page 865, the top of the page, that the Bax itself was another intermediary. It was it sent credit and debit instructions to each of the member banks, which would then make the appropriate debit or credit.
Yes.
So it wasn't. So it's another intermediary, but Lord Justice Law's notes between B and C that banks' supplies were, at least at that time, treated by the commissioners as exempt.
Yes, indeed. As I say, my belief is that hasn't changed, but we'll see. So, my only purpose, apart obviously from, if I may say so, the wisdom of Lord Justice Laws about these matters, in showing this to the court, is to make the point that no one has ever suggested that His Lordship got SDC wrong as it then stood. And the only reason I say that's important is because if we are fortunate enough to win the argument on SDC, then FDR remains good law. At the moment, the Court of Appeal have said FDR should not be followed, but they haven't said, and certainly haven't said with any clarity, what it is about SDC that has been the subject of the evolution or elaboration, which is said to have occurred. I think I may postpone, I'm slightly conscious of time, I may postpone looking at the Court of Appeal judgment just to get through some more of the cases, because what we've done so far is look at the SDC and FDR, which are a unit. My thesis that there are two different strands of cases depends on showing you the other pure bank subcontracting cases, Nordea and Cardpoint, where there's no hint of avoidance, and drawing a contrast between those and the avoidance cases. And the point I will seek to make is that both Nordea, which is pre-DPAS, and Cardpoint, which is post-DPAS, both use SDC with any shortcomings that it may have as nonetheless the guidebook to this area. Nordea is at page 680 of the electronic bundle. In both of these cases, the taxpayer lost. The Crown suggests that's evidence of a movement in the SDC landscape. We say no, these are cases which the taxpayer was always going to lose, because in the Nordea case, the taxpayer, the SWIFT entity, was essentially a postman. It delivered the electronic message without ever accessing the contents. It was a sealed envelope which it delivered. So it's a direct analogue of the men on the motorbikes going up the M1 with the Bax tapes in the 90s. In Cardpoint, the taxpayer lost. The taxpayer filled up the hole-in-the-wall machines with cash and did various accounting processes around that, but critically was not able to speak to the equivalent, the German equivalent of the Bax system. It didn't have the ability to speak to the interbank data chain. And we say that in both cases, if the law had indeed moved on, and certainly in the Cardpoint case, which is post-DPAS, it would have been a very simple matter for the court to say, look at DPAS, only a bank can access this exemption now. So I fear there's nothing for you here, whether you can speak to the banking system or not. So coming first So those are my very limited ambitions for these cases, just to essentially say this is business as usual, and that SDC hasn't been rolled back. So looking at Nordea on page, so this is the one about Swift messaging services. If you look at 683, you'll see the description of Swift. In para 11. And the analysis is on pages 685 and 6. And one sees at the beginning of para 24 on page 685 that there is a reference to settled case law. So I realize it's 12 years ago, but certainly as at 2011, the case law, which includes SDC, as you can see from the bottom of paragraph 24, included SDC, paragraph 66. I won't read 24 to you because you've seen these words elsewhere. And equally, it's using at para 25 execution, that word, in the sense that it was used in SDC, because at 25 the last reference is for SDC at paragraph 53. And again at 27 it makes the point, relying on SDC at 59, that, quote, operators external to financial institutions which therefore do not have a direct link with the clients of those institutions, end of quote, can nonetheless be exempt. So we say that's flatly contradictory to the...
Sorry, where is the further reference?
My lord, that further reference was at 27.
Thank you.
And citing SDC at 59.
Thank you.
So at 28, one sees what was done in our case before the court only by the first tier, simply applying SDC to the subcontractors' processes. And the detail perhaps doesn't matter, but 685 I cite just to indicate the stability of the case law, but at 686 one sees at para 30, which is a one-sentence paragraph, however, as indicated by the referring court, all the member states who've submitted observations and the European Commission without being challenged by Nordea, SWIFT services are electronic messaging services by means of which payment orders and orders concerning transactions in securities are transmitted from one financial institution to another in a secure and reliable manner, and SWIFT does not have access to the actual content of the messages thereby transmitted. And notwithstanding that, the court goes on carefully at 31, again citing SDC, to go through the test, and indeed at 33 on page 686 the court slightly reformulates the SDC paragraph 66 test. It says it's also clear from the case law cited in 24 to 26 of this judgment that the legal and financial changes which are such as to characterize a transaction exempt from VAT result only from the transfer of ownership, actual and potential, or potential in funds and securities without it being necessary for the transaction thereby performed to be effective against third parties. So that's, if anything, I don't think it matters for our case particularly, but the court has added the words or potential, whereas in SDC they weren't there, and the court has added, I think in the context of securities, not in the context of the case before this court, the fact that there may not be third-party protection. But then the court delivers the coup de grace and says, accordingly, if, this is 34 on page 686, if SWIFT services are electronic messaging services which are simply intended to transmit information, they do not by themselves perform any of the functions of one of the financial transactions referred to in 13 BD 3 and 5 of the 6th Directive. That is to say, those which have the effect of transferring funds or securities and do not possess the character of such transactions. I think I'll move, if I may, to the next case, because that was quite a humdrum.
Does SWIFT then interact with banks? Is it through SWIFT that the bank's messages get to banks?
I don't know. This is one of the problems about not having looked at this evidentially. I can take instruction, talk to my learned friends, see if we can common position. One tends to associate SWIFT with payments abroad, but perhaps that's just my own perception. But there are all these mysterious things as IBAN and SWIFT, etc. And they're all subtly different, and one has to be precise. Can I invite the court to look next at card point? Card point is at tab 15, page 772. Another humdrum case, perhaps, but important because it post-dates DPAS, and it's a way of testing whether DPAS was the watershed that the Court of Appeal saw it as. I will avoid getting into too much detail here, but if one looks at, first of all, the Advocate General, and the first thing to say is it's interesting that an Advocate General was involved. It's obviously indicates court wasn't quite sure if it was going to be business as usual on the issue, and the Advocate General bot at page 7, well, perhaps we can look at 773 at the top. He says at paragraph 4, in this opinion I shall set out reasons why I consider that in circumstances in which a bank outsources activity to a third-party undertaking, the activities relating to the operation of ATMs carried out by the third-party undertaking, consisting in operating and maintaining the ATMs, replenishing them, installing computer hardware and software in them to enable them to read bank card data, sending a withdrawal authorization request to the bank that issued the bank card, used and registering withdrawal transactions are not covered by the exemption laid down in Article 13 BD3 of the 6th Directive. And I will pay particular emphasis to the request and the registering of withdrawal transactions, because as will be seen, if you send a message after everything has happened, you cannot claim to be exempt as having affected the transaction. The data handler must, if I can put it this way, make history, not just record history that has been made by others. That's bookkeeping. So one has to be vigilant in all cases to see what the timing of the messaging is. And this is a point that will come back when we look at DPAS and Bookit, because there's an end-of-day roundup message to a merchant acquirer, and that came too late to pass the paragraph 66 test. So at 8, which only requires a glance, the process undertaken is summarized. At 9, the there's a reference to the interbank network, which would pass messages to and fro, and that, I suggest, is the equivalent of the BACS network. If I can just read it from the fourth line of 9. Next, Bank Verlag would forward the request to the interbank network, which would in turn pass it on to the bank that issued the bank card concerned. That bank would verify whether the account holder had sufficient funds in his account and send back via the same channels an approval or refusal of the withdrawal requested. Upon receipt of the reply, CardPoint would generate a data file on the cash withdrawal and, if authorized, implement the requested transaction and generate a data file on the withdrawal. Lastly, that data file will be sent as a payment order to CardPoint's contractual partner, that is to say, the bank operating the ATM in question. The latter would transmit the unedited data files to the record system of the Deutsche Bundesbank. CardPoint would also generate a daily non-editable list of all the day's transactions, which would be sent to the BBK. Since only banks are entitled to hold settlement accounts with the BBK, it was they who transmitted the data files to the BBK's record system. That data transfer rendered legally binding the right of the bank operating the ATM in question to obtain reimbursement from the bank owning the account affected by the transaction and payment of any changes thereby incurred. Charges, forgive me. Transfer of the data also had the immediate effect of recording in the accounts the clearing as between the bank operating the ATM and the bank that issued the customer's card of the amount paid out plus any charges incurred from that ATM. So this is an example where, unlike FDR and unlike my current clients, the data handler can't speak directly into the system which causes the transactions to occur or the alterations to occur. And that, we say, it is a fundamental difference. So over the page...
I'm sorry, just before we leave it, in paragraph 9, the vote said that if authorised, CardPoint would implement the requested transaction. So I take it that means that CardPoint is responsible for the delivery of the banknotes.
Yes.
But in paragraph 10, the bank operating the ATM obtains reimbursement from the bank owning the account. So if you were a customer of Bank A and you withdraw money from Bank B's machine, you're actually being paid banknotes that belong to Bank B, and it then obtains reimbursement from Bank A.
Yes.
Right.
And the court takes the view that handing over the banknotes is not per se a financial transaction. It's just as security vans travelling around London are not involved in an exempt anything. It's just goods, delivery of goods. So the Advocate General, I cited those passages because of the detail into which he went. The question is at 16 on page 775. In that regard, the referring court emphasises the similarities between the situation at issue in the main proceedings and those which gave rise to the judgment of Bookit. Thus, CardPoint obtains the data from the account holder's bank card and transmits those data to the bank that issued the card. Moreover, CardPoint is not responsible for verifying and approving individual orders, since it does not perform the requested withdrawal transaction until after it has been authorized to do so by the issuing bank. So pausing there, card point doesn't make history, it just does what it's told. And then at 24, still with the AG...
Well, sorry, just on that, I mean, it makes history in a certain sense in that it delivers the banknotes.
Precisely.
It's only because the banknotes have been delivered that entries then appear in various accounts, both between banks and between bank and customer, isn't that right?
Well, ultimately, yes. But the view is taken that delivering the banknotes is not of itself, it's not a Section 66 event. What
I follow that. Yes. I was really just questioning how useful your metaphor of making history and recording history is.
Well, I think once banknotes are in handing over banknotes, which are very, very historical, the metaphor may break down slightly. But if one is in an e-money world where there's no complication of banknotes, then my lord, I would propose that it's the metaphor that separates bookkeepers from those data handlers who are mere bookkeepers, from data handlers who actually can cross the bridge, paragraph 66 of Spark Personas, and actually say what we did with the data meant that money moved, that there was a transaction concerning debts. There was an alteration in the legal and financial landscape.
If one thinks back to the days when banks had tellers, you could imagine a situation where the tellers were all employed by some outsourced organisation.
Absolutely.
That organisation wouldn't be executing transfers simply because it employed the people who handed over the banknotes.
No, exactly. That's very helpful. And indeed, this is an automatic teller. I think that is sometimes the phrase used, and it's good to bear that in mind. So, what happens on 776, and this is more the archaeology of the case law that I'm referring to on this page. At 24, there's a reference to a payment directive. I just say that in passing. I don't think it's something to fasten on. At 28, the Learned Advocate General says, in that regard, I, like Card Point, take the view that in that judgment, that is to say, book it, the court did not depart from its previous case law. And that's part of my respectful challenge to the Court of Appeal. It certainly would appear to this Advocate General that book it, which obviously isn't a DPAS, but didn't represent a departure from SDC. 30, at 30, he says, in reaching that conclusion, talking about book it, the court noted in particular that the supplier of that service didn't itself directly debit or credit the accounts concerned, that it didn't act by means of accounting entries, and that it did not instruct such debit or credit. And that's a third limb. It didn't instruct such debit or credit, which we say is, with respect, accurate and aligns the law as it was left in Bookit with the law as it was left in SDC. And I'm presuming, yes, and at 31, he says, it should also be noted that in its most recent case law, the court has confirmed that approach, and as one turns the metaphorical page at 777, we see that he is referring to DPAS. So if one, just pausing, just looking at this structurally, he is certainly pointing to an entirely stable judicial landscape running from SDC through to Card Point. That's really the point that I seek to make from that. And then he gets more into the actual detail at 34. He also, at 34 on page 777, mentions the fact that one has to look at, well, I just read the first sentence. More specifically, for the purposes of characterizing the services exempt from VAT as transactions concerning transfers or payments, the court has regard first and foremost to the nature of the services provided, in the sense that those services must relate to the sphere of financial transactions in order to be exempt. So that pops up again. Accordingly, the services must be assessed against a functional criterion in order to determine whether they fulfill the specific and essential functions of such transfers or payments, in the sense that they have the effect of transferring funds and entail changes in the legal and financial nature of the transfer. And the extent of liability borne by the service provider is mentioned, and we've debated that to some extent in the course of the discussions about what my clients are paid to do, what BACS does, and what others do. And at 36, as on page 777, as regards the functional criterion, it should be noted at the outset that CardPoint itself acknowledged in its observations that in accordance with the judgment in Bookit, the capture of an ATM's user's bank card data, the transmission and verification of those data, and the execution of the transaction requested by the card holder following receipt of the authorization message from the bank that issued the card concerned cannot fall within the scope of the exemption. The view that he takes, perhaps at the top of the next page, 778, 39 and 40, he says this at 39: it thus follows from the information provided by the referring court recalled in points 8 to 10 of this opinion that, as the German government has emphasized, the service supplied by CardPoint does not directly entail the act of debiting or crediting an account itself, or acting by means of accounting entries in the accounts of the holder of the bank card used to make a withdrawal. Indeed, CardPoint transmits the data from the user's card and the request for authorization for the withdrawal sought by the user, but executes the transaction in the sense of physically releasing the banknotes only if the request is approved. And yes, 40 is material. Moreover, only the bank that operates the ATM transmits the data files to the BBK's records system. The daily non-editable data file containing all of the day's transactions, which is generated by CardPoint and sent to the BBK, is intended to notify the BBK of the authorized transactions carried out, and cannot therefore be regarded as fulfilling the specific and essential functions of a payment. In other words, it comes afterwards at the end of the...
So if at 36, CardPoint itself was acknowledging that doing all those things did not come within the exemption, what is it then that they said that they did in addition to that they based their claim to exemption on?
I think the focus was, they weren't saying that the physicality did it, but it was a question of the messaging, and the court took the view that, the court took the view that the interaction that it had with the user of the ATM was not sufficient to get it across the line.
But is that what CardPoint was relying on?
I'm looking at 54 and 55, which is the court explaining, or we're still with the Advocate General. As I understand it, CardPoint were trying to argue that its interaction with that process, or the release of funds, gave it some basis for accessing the exemption, the court at 8 on page 783 I think possibly captures it in the middle of para 8, where it says, if authorized, CardPoint would execute the withdrawal at the cash point and generate a data file on that withdrawal. I'm looking at the middle of para 8, the court, 783. If authorized, CardPoint would execute the withdrawal at the cash point and generate a data file on that withdrawal. It sent that data file as a payment order to its client, the bank operating the cash point in question. That bank transmitted the data files unchanged into the record system of the Deutsche Bundesbank. So it's at that point that someone else interacts with the general system, and then CardPoint would also generate a daily non-editable list of all the day's transactions, which would be sent to the German Federal Bank. That data evidenced the right of the bank operating the cash point in question to obtain reimbursement from the bank of the account holder who withdrew the money and payment of any charges incurred. But that didn't have the effect of actually creating any liabilities. It was recording events that had already happened. And the court at para 20 on page 784 again indicates, in dealing with that it's guided by SDC, which it describes at para 21 as, on page 785, as settled case law. And at 25, perhaps best answer to my lady's question, in the present case, according to the order for reference, CardPoint did not directly debit the bank accounts in question, but affected the physical delivery, etc. So at 26, it follows that the services supplied by CardPoint do not appear to be capable of effecting the transfer of funds or bringing about changes in the legal and financial situation which characterize a transaction concerning payments within the meaning of Article 13 BD3. Indeed, contrary to the facts at issue in the case which gave rise to the Bucket judgment, the services supplied by CardPoint weren't confined to the exchange of data between the issuing bank and the bank operating the cash point, but also concerned the physical delivery of cash. However, the supply of cash during a withdrawal from a cash point did not effect a transfer of title from CardPoint to the cash point user. It was the issuing bank which authorized the cash withdrawal, which debited the appropriate amount from that cash point user's bank account, and which transferred the title in the money directly to that cash point user. Furthermore, 27, as the Advocate General states in point 40 of his opinion, only the bank that operates the relevant cash point transmitted the data files to the German Federal Bank's records system. The daily non-editable data file containing all the day's transactions, which is generated by CardPoint and sent to the German Federal Bank, was intended to notify the latter of the authorized transactions carried out and cannot therefore be regarded as fulfilling the specific essential functions of a payment. I hope that in this extremely technical case, those last two paragraphs indicate that CardPoint needed the court to tell it that handing over the money was not a payment event. The interest in submission to the court is at 27, which makes the point that it's important who interacts with the interbank system. You can't have more than one person interacting with the system claiming to be the person who affects the transaction. It's got to be clear that one person and one person only has that privilege, and CardPoint didn't have it.
So it's saying they did a bit more than was done in Bookit,
Yes.
but the bit more that they did, which was the triggering the delivery of the physical cash from the machine, was not sufficiently more to bring them within the exemption.
Indeed. It's basically saying that all of the relevant money movements happened in the electronic world. And because CardPoint couldn't speak to the banking system, it didn't therefore do anything exempt.
I'm not sure it is as narrow as that, because in paragraph 26,
Yeah.
they focus upon the supply of cash as well during the withdrawal, and they say that the withdrawal did not affect a transfer of title from CardPoint to the CashPoint user. It's the issuing bank which authorised the cash withdrawal.
Yes.
So, I mean, it doesn't seem to me that the court is focusing just on electronic entries. It's also focusing on the delivery of the cash, but they're making the point it's not a delivery of cash in the sense of title moving from CardPoint to the customer, it's from the bank to the customer.
I accept that. Correction. I think CardPoint was pinning its hopes on the cash and/or its end-of-day message, and since neither of one of those may well transfer physical title to the banknotes, but the other one just came too late to make a difference. The big point.
So can I just ask, I mean, there are different transactions going on potentially in what's happening
Yes.
in CardPoint. You've got the delivery of the cash to the customer, which involves both physical delivery of money, and we see them talking about the title to the physical money, but also debit entries which will ultimately need to be made in the account of the customer with their bank.
Yes.
But there's also a transaction in the sense of debit and credit entries between the paying bank and then the CashPoint bank and the reimbursing
Indeed.
bank. Was there a focus in CardPoint on which form of transaction was being looked at for the purposes of the exemption, or is it just the whole bundle?
By the whole, well, it was clearly a 13BD3. Sorry, by the whole bundle. My lord means the factual bundle, not
Yeah,
exemption.
I mean, the transaction involving delivery of cash to the customer, debiting of the customer's account, and the debits and credits of the ATM bank and the reimbursing bank.
I suspect the first two, but not the last.
All right. Can you help us where the court focuses down on the first two and not the last?
Well, I was thinking of the paragraphs that I had just read, because 26. 26 indicates services supplied by CardPoint, line 5, were not confined to the exchange of data between the issuing bank and the bank operating the relevant cash point. But the impression I got was that CardPoint, and I can check this, were not suggesting that just that they had an exempt role in just ferrying authentication details between the two. I mean, that's a classic technical supply.
But wouldn't it turn on to whom was CardPoint supplying the services that it supplied? Was it to the bank whose cash it is, or is it the bank, the customer's bank? It must. I would have thought it's the ATM.
So CardPoint offer a technical service to the owner of the ATM, which may be a bank or a supermarket or whatever. Well, let's keep it as banks. But I don't think they were suggesting that sending those messages, taking the 4-digit number and dealing with that was itself an exempt supply. But the impression I got was that it was the end-of-day data file transmission that it was trying to argue, if it couldn't get home on the cache, it's trying to argue that that was a paragraph 66 type supply, exempt supply. I should say this. I don't urge the court to get enmeshed in the detail of the card point case because I'm citing it simply for two reasons. There's no cache in our story, obviously. One is the archaeology of the case law, as it were, and that the court, the Advocate General and the court behave as if the body of case law going back to SDC is settled. So it's that somewhat anecdotal point. And secondly, quite different point, the inquiry does come down to the level of who do you send your messages to, what is the nature of your authority in sending the message, how are you perceived at the other end, and do your messages cross the line into the banking system or not? In other words, the scalpel is applied very precisely to this exemption, as is appropriate. If DPAS had made the difference that the Crown says it made, all that the court would have needed to say is, afraid you're not a bank, and only banks can execute, I'm now paraphrasing our Court of Appeal, and subtleties concerning messaging and so forth are really beside the point. You cannot claim to have executed anything because you don't have the status of a bank. And that is extremely different from the very technical and precise analysis that the court goes through. That's really that's really all I wanted to say about that case.
They do, perhaps you should note, at paragraph 23, they indicate that it's not essential that the service provider should directly debit or credit an account or make accounting entries in the accounts. But if you were doing that, obviously the condition would be met. That is, say, the fact that the service doesn't directly involve such a task doesn't mean the possibility of exemption is should be immediately ruled out.
Indeed. Well, that's of a piece. I'm grateful to your lordship. That's of a piece with the submission I'm making. I'm passing from the technical world of those cases where there is no complicating factor in terms of the nature of the supply to the British cases, the first of which is Everything Everywhere. I could deal with it quite quickly now or at a convenient moment later.
Shall we sit on for a few minutes?
Yes, with great pleasure. So Everything Everywhere is, let's find it, page 1144, that's physical tab 32. And this is one of a number of avoidance cases. I can summarize it quite quickly. We're not into the interstices of the banking system here, but we're into a fairly simple proposition. This case occurred in 2011. The simple proposition is, so we're now back in retail world. One gets one's bill for one's mobile phone, and one sees that there is a charge made if one chooses to pay in a certain way rather than in another. So the mobile phone company says if you pay by cheque, we'll charge you. If you pay by direct debit, we won't charge you. And at that point, the commissioners become interested because it is said that the supplier of the telephone service can nibble away a little bit of its otherwise taxable turnover and reassign it exempt status as the making of a supply or transaction concerning payments, transfers and debts. And alarm bells ring, of course, in the Treasury, no doubt everywhere in Europe, because every retail supplier, or indeed every supplier, wants to be paid, and it is theoretically possible to make a supply to one's customer of agreeing to be paid in a certain way, and then saying, well, that must be an exempt supply of a transaction concerning payment. And as you will see, the European Court saw where that was potentially leading and firmly closed the door on it by very simple means. That is to say, you signed up for a supply of telephone services, taxable. The fact that around the edges you might have got some purported exempt supply of their taking your money in a particular way will be subsumed on card protection plan principles, as they're called, drawn into the taxable overall supply.
If it's a composite supply, the
Exactly.
predominant factor is a taxable one.
Precisely, my lady. But I'm showing you this because it then rolls into the other cases, which we'll see after the short adjournment. So the court's reaction to this, this can be quite short. Page 1151. It's at the court. At 27. Well, at 26, there's a reference to CPP, which is the point my lady just made. At 27, on page 1151, with regard to the main proceedings, it's to be noted that the principal service supplied to its customers by a provider such as EE is a mobile telephone service. The activity engaged in by that undertaking in invoicing for that service, in particular making available to customers an infrastructure enabling them to pay bills, not only by direct debit or by BACS transfer, but also by credit card, cheque or cash, doesn't constitute for those customers a name in itself. The supposed supply of services which those customers are unable to access separately from the use of the mobile telephone service can offer such customers nothing that is independent of that service. It offers them only the opportunity to pay mobile telephone bills using the method of payment that appears to them to be most convenient, and moreover enables the supplier of the services to increase the volume of the service it supplies as its main service. And then skipping 28, 29 makes the point that if the price is invoiced as single or separate, that won't affect the VAT analysis. And at 30, it follows that EE's customers who pay their mobile telephone bills using one of the payment methods which incur the SPHC, that's the charge, do not intend to purchase two distinct supplies, namely a supply of a mobile telephone service and a supply whose purpose is to handle their payments. From the customer's point of view, the supply of payment handling services supposedly provided by the telecom services provider to its customers at the time that those services are paid for using certain payment methods must, in circumstances such as those of the main proceedings, be regarded for VAT purposes as being ancillary to the principal supply of telecoms services. And that concludes the citation.
If that's a convenient moment, we'll adjourn until 2 o'clock.